Do several alleged errors by defense counsel constitute ineffective assistance of counsel? To find out, you have to read People v. Howard, but it's 14 pages. Don't have time for that? I've got you covered. This is the episode on the case of People v. Howard. The citation for this case is 2025 New York Slip Opinion 00184, published by the New York Court of Appeals on January 14th of 2025. The issue in this case is whether a series of identified alleged deficiencies by defense counsel constitutes ineffective assistance of counsel that would justify reversing a conviction and granting a new trial. To understand and appreciate the context of this case, the helpful background to know is that a claim of ineffective assistance of counsel, which is basically a deprivation of the Sixth Amendment right to counsel, guaranteed by the United States Constitution, Bill of Rights, there's two different standards to assess whether there's been ineffective assistance of counsel. There's the federal standard and the New York standard. The federal standard is called the Strickland test. Under the federal standard, the person must show that the attorney's errors fell below an objective standard of reasonableness. That's the first element, fell below an objective standard of reasonableness, and that the errors prejudiced the case so as to undermine the confidence in the outcome, meaning that there's a reasonable probability that, but for counsel's unprofessional errors, the results of the proceeding would have been different. So number one, below the objective standard of reasonableness, and the outcome was impaired or was affected by that defective representation. And the New York standard is different. The New York standard is theoretically, it's a higher standard. It's the meaningful representation. So it's where counsel's errors individually or collectively deprive defendant of meaningful representation. It's considered ineffective assistance of counsel. Okay, so what are the facts in this case? The facts are, and I'm going to get all these from the dissent. The actual majority opinion is very short. It's like only 3 or 4 sentences. The dissent is quite lengthy. The facts of this case allegedly are the defendant was charged with burglary in the first degree and assault 2, and aggravated criminal contempt and resisting arrest. Basically allegations that the defendant went to his spouse's house in violation of an order of protection, came into the house, and violated the order. When the police came, he tried to fight with the police. He was assigned counsel. That counsel allegedly, in the course of this representation, filed an omnibus motion that misstated the law, misstated the evidence, misstated the facts, referred to drugs, a search warrant, confidential informants, and wiretap evidence, even though the actual facts in this case never involved drugs, search warrants, confidential informants, or wiretaps. He told the court that he includes those things in all his motions, even though it doesn't apply in this case. The defendant in this case, during the course of the representation, complained several times to the judge, saying that the representation by counsel was ineffective. The counsel admitted that he didn't show the body cam footage to his client before the hearing and only 1 week before trial. He failed to request striking testimony that had been precluded by the Sandoval ruling. At trial, he elicited from the people's witnesses a lot of things that wouldn't have come out that show that the defendant had previously allegedly violated the orders of protection and allegedly had gone to the spouse's house when he wasn't supposed to. And ultimately, the defendant was convicted. And after he's convicted, he makes a motion to reverse based upon ineffective assistance of counsel. The appellate division affirms the conviction, says it's not ineffective. It goes to the Court of Appeals. And here, what we have is a 5-2 split. The majority is the one issuing that like 4-sentence decision saying it's not ineffective. They cite to Strickland. They cite to the New York standard. They say it is not ineffective assistance of counsel. So the conviction is affirmed. But the lengthy dissent here by Judge Rivera and joined by Judge Wilson, I believe, goes through all those facts I just mentioned and says this is ineffective. They would grant the reversal. But once again, that whole litany of facts that I obtained from the dissent is not considered ineffective assistance of counsel by the majority. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.